Hello, everyone. Welcome to the Arbitration channel. Today, with one more session of the HardTalk. The HardTalk is sponsored by Leste Litigation Finance, MAMG Advogados, Simonágio Certeza Técnica, and Tosini Freire Advogados. Today, the Arbitration channel invited me, Fernando Marcondes, partner of MAMG Advogados, as moderator, and we have three megastars as speakers. First, Janet Walker, Distinguished Research Professor at Osgoode Hall Law School from Toronto, Canada, also a recognized international arbitrator and chair of the ICC Canada. Eleanora Coelho, also a distinguished Brazilian arbitrator and president of CANAL. And last but not least, far away from that, Professor Doug Jones, a leading international commercial and investor state arbitrator, judge of the Singapore International Commercial Court, and one of the biggest names when we talk about construction law. When Lauro Parente invited me to organize a session of the HardTalk, my first thought was to call Doug Jones and Janet Walker. They have been in Brazil several times, always collaborating as speakers in different conferences, including one of the international conferences that I had the opportunity to organize when I was the president of the Brazilian Institute of Construction Law. Doug also gave me the honor to accept my invitation to write one of the chapters of the last book I coordinated, which is called Direito da Construção no Ambiente Internacional, or Construction Law in International Environment. Doug wrote about collaborative construction contracts. When Doug and Janet suggested to talk about construction arbitration case management, the new normal, my dear friend Eleonora came to my mind at the very same second. I am aware that the CAMCCBC has been doing several adaptations to make it possible to go on with the vast number of arbitration proceedings they have. So I thought that Eleonora was the natural choice to complete this panel. Well, for a moderator, I already talked too much. Let's listen to the stars here. I prepared some questions, and I'd like to start with Janet. Janet, very welcome to Brazil, virtually, unfortunately this time.
Obrigada.
I'd like to ask you, with the increased familiarity with virtual meetings and electronic bundles, how are our perspectives changing on virtual hearings?
Thank you, Fernando. It's been remarkable, the transformation in our comfort with virtual hearings and with virtual meetings over the last year and a half. I'm amazed when I stop and think how we've climbed a learning curve that may have required 10 years or more. The technology was there, but we were simply not used to it. And yet with the pandemic, we've all been propelled forward rapidly, ever so rapidly into the future. I think step by step, we've seen from the early days of early adopters who are comfortable, but many, many more who are quite reluctant, to today in which you don't even think of convening a teleconference. Who would do such a thing? And yet you are not also hesitant to arrange to meet because it's no longer necessary to bring everyone physically together. So it's just been a huge change in attitude and approach. There is so much more now that can be done throughout the life cycle of the arbitration, now that we're simply able to send that Zoom invite and bring everybody together in one place for a discussion, just as we're having now.
Yes, of course. Doug, I'd like to comment that.
Yes, well, I suppose the reaction one is getting nowadays, after the year and a half that Janet mentioned that we've been in this really strange environment of COVID, is when can we have a real hearing again? When are we going to return to what so many people regarded as normal? And I think there is a very significant emotional issue floating around the international arbitral community. It was only yesterday that I exchanged emails with fellow tribunal members in relation to a hearing scheduled for late November in either London or Geneva, and a hearing scheduled for Singapore in December. Of course, the immediate reaction was, well, at last we may be able to have an in-person hearing. And then the immediate follow-on was, but can we get in? Can we get out? What sort of quarantine restrictions will there be? Is it ever going to be possible? So this level of uncertainty and frustration, which is developing, is something that I'm sure you all have experienced and all of our viewers will have experienced. So the question to my mind is this: how can we move forward to take advantage of the technology that we've now deployed? As Janet says, technology that was there but which we really weren't effectively using in international arbitration, without an overlay of resentment for not being able to actually meet in person. What sort of balanced outcome can there be for the future to develop that? I mean, if we are looking, as I think is the case, for the two events that I just mentioned, Geneva and London in late November and Singapore in December, at no real possibility of in-person hearings. And I know Janet has a hearing in Sao Paulo coming up in December, where there is that same level of uncertainty. We will be faced with the reality that we're going to have to do it virtually. But what we need to think ahead about, effectively using the technology that we have discovered, is how to introduce that for the future so that we take advantage of this virtual world that we're reluctantly in and use it effectively in a time when the constraints will no longer be there. So the perspective is a little bit schizophrenic, I think. There is, goodness me, when is all this going to be over and we can actually be together again, on the one hand, and on the other, we've found all these ways of effectively communicating. What can we continue to do in the interests of efficiency of international arbitration when we could fly miles, chew up a whole lot of carbon imprints around the world and actually meet like we used to do, but can find a better way of doing it? So I think the perspectives need to be balanced between these two competing issues. And I'm not sure that we're there yet, because if you'd asked most of our contemporaries in this field late last year, they would have said, oh, there's no problem. We've scheduled a hearing for July 2021, and that'll have to be in person because all this will be over. But it's not. So I'm not sure that we've really got a way of sorting out how we're going to do this. The truth is, though, if you take the emotion out of it and the resentment of what has happened to us, we have found a whole lot of tools new to the international arbitration community that we can and should adapt to the new normal once it becomes normal.
That's right. That's right, Doc. I miss some things of the older time, the old times. I miss my friends. I miss to have dinner with my friends in the international conferences. But in 2019, before the pandemics, I had 19 international trips. I don't miss that time. I don't miss the airports. I don't miss the planes. I don't miss the hotels. 18 months that I'm here working from my home, and I'm really happy here. I don't want that life again. So I think that the 19 trips for 2019 will be maybe 3 or 4 or 5 for a year, but not more than this. It's insane. We didn't realize that it was insane. Now I think we have a new perspective. It's really different. Eleanora, your thoughts?
I totally agree. I think that the virtual hearings came to stay, especially because of the costs. Of course, that we have a few disadvantages, a few challenges that we're going to talk about, but we can overcome these challenges as we have been overcoming. And according to CAMCCBC numbers, we have had a reduction of 93% of costs with the virtual hearings. This talks for itself. And even after the physical hearings were authorized, we still have 96% of virtual hearings, and only 4% divided into hybrid and physical hearings. So, even having the opportunity of having the physical hearings already, with all the securities, with all the measures taken that we're going to talk about also, parties are, confirming this tendency and like this new tool, as Doug mentioned, to make the arbitral proceedings more effective, more efficient, especially in construction cases. We're going to talk about that later, but that, I think the numbers speak for themselves.
Yeah, for sure. And you are talking about the economics in the chamber, in the CAMCCBC. I can realize how much we are not spending with trips of lawyers and testimonials and experts and everything, and hotel, etc.
And the planet thanks, right, Fernando? And the planet,
Yes.
the environment, it's much more sustainable. And what's the point of traveling, having people come from different countries, for instance, for a terms of reference hearing,
Yeah.
like, or other simple hearings, such as presentation of the case, and even in complicated hearings, we're going to talk about how to overcome the challenges. There are tools in order to overcome and to make this very effective indeed.
Yeah, you're right. Doug, what are the challenges for arbitrators and counsel specifically?
Well, I think for arbitrators, there's been a real technology learning curve. I can't speak from personal experience of Brazil and Brazilian arbitrators. My experience is of arbitrators in other parts of the world, some of them very sophisticated economies such as the US and the UK, where I think arbitrators have taken the view in March last year that this was all going to be a temporary inconvenience to the trips that you described, Fernando. We'll soon be able to get back on aeroplanes and we won't have to work from home for very long. So there was a lack of investment by arbitrators in the technology. And it is really amazing to me, as a sort of a Canadian, come Australian, come UK resident, that when you get out of the cities in the UK and the US, the internet coverage is really appalling. So there have been quite a number of arbitrators ensconced happily in their country houses in the USA and in the UK, who have dreadful internet connections, who are always fading in and out of the hearings, and who have simply not invested the relatively minor amount of money that would be necessary to upgrade their internet connections, get satellite, get the screens they need to be able to handle the hearings, and to adjust to what has turned out to be a new normal. And some of these people are still struggling on a year and a half later, hoping I suspect that they will return to their offices. So that's the first challenge for arbitrators. And I think, to be blunt, if you're in the game of being an arbitrator, you can be expected by the parties to be to be up to speed with the technology. The cost of a really good internet setup and the screens and gear that you need to run a hearing from a home is insignificant compared to the cost of one of your airfares, Fernando. Insignificant. I mean, just to take example, I'm speaking from a video suite at the home we have in Toronto, where we purchased a separate gaming computer to run the video because we were having trouble with our video connections. We have another computer which drives the databases, and with massive TV screens sitting in front of us where we can see everyone. And all of that, it would have $5,000 was all it would have cost. And that investment, which we made in March last year, has paid off enormously. So I think arbitrators need to be challenged to get on board with the technology. The second challenge for arbitrators, I think, is all the stimuli. Now, with an appropriate number of screens, you've got the video image, you've probably got two separate databases, your own database of the documents and then the parties database that you need to swap in and out of. And then you've got the images which are presented for submissions or for cross-examination. And that's all coming at you through these screens. Now, it's said that our children suffer from too much attention to video games and the like. I'm not a video gaming person, although we have a video gaming computer running the videos because they're just good at doing that. But what I find is that all these stimuli are really challenging, just tiring in terms of efforts of concentration. And I have found that when electronic hearings were in person, that is, all the documents were in a database and one didn't need to have these massive piles of paper that one used to have. Now that we have these stimuli coming at us from all these screens, it is necessary to have more hard copies than might have been the case for in-person hearings. So the challenge of managing the fatigue and being able to stay on the ball for the period of the hearings is a critical matter. And I don't know how Janet and yourself and Eleanora have found it, but I think more regular breaks than one necessarily sees in in-person hearings is necessary. And the possibility of there being shorter periods of total hearing per day are things that need to be considered to manage the hearing process. So those are the arbitrator's challenges, among others. Managing the process, of course, is different. A whole lot of logistics to ensure that everyone turns up on screen on time and has the correct connections and knows how to manage the process. Lots of trial runs to make sure that people are organised and the like, needing to be led by arbitrators. That's important too. So different sort of management. For counsel, I think it's involved an adjustment of the presentation process. Obviously, your civil law approach to advocacy is different to the common law approach. But all of you will be familiar, of course, with the vigorous advocacy that comes from common law advocates. They've found, I think, in this virtual world, that bombast and physical dominance of a hearing room has suddenly disappeared. So the advocacy techniques that they've had to develop, both for submissions and for cross-examination, has had to be adjusted dramatically to a different environment. And that's not saying that I think cross-examination is ineffectual in a virtual environment. I mean, it's very rare, I think, that you would, in a in-person hearing, see a witness's face as clearly as you can on a video. However, what you can't see is the feet language and other things, other aspects of who is reacting to what in the room. So from a counsel perspective, that is an interesting question. And in my role on the Singapore International Commercial Court, where all of my engagement there for the last 2 years has been virtual, there is the difficulty when you have a multi-judge court of watching the reactions of the judges. The same thing applies, of course, to the tribunal, because you just see each individual tribunal member, and the interreactions between the court members or the tribunal members isn't there for the clues for advocacy. So counsel have had to adjust to that. The other thing, of course, that counsel have had to adjust to, and arbitrators and witnesses, is the fact that although they haven't got on aeroplanes to get to a hearing, they've either had to get up very early in the morning or stay up very late at night so that everyone's in the same hearing. And that sort of adjustment to time zone differences, which you may not have so much with your Brazilian hearings, I suspect, but which you certainly do from the perspective of international arbitration in Brazil, represents fatigue, concentration, and other issues that is a significant challenge for counsel.
Sure. Thanks, Doug. Eleanora, I'd like to hear your thoughts.
I totally agree with Doug. I think these are the technical, I would divide into technical and logistics challenges. The technical, of course, that arbitrators can learn how to deal with technology and can buy better instruments and tools and computers and so on and so forth. But it's very important for them to understand how to deal with them, because sometimes we see that arbitrators, they don't know how to deal, they don't know how to share the presentation, they don't know how to, to access a document that has been shared by a party. So it's very important also to learn how to deal with this new technology. And the logistics perspective, I think it's very complicated, and something that would help is to have like a checklist, because sometimes it's an ad hoc arbitration, or the arbitration institution does not have rules on conducting of hearings, for instance. So it's very good to have this checklist in order to check if the time zone is okay, if the parties, the witnesses, the experts, the attorneys, they fulfill the conditions for participating in an adequate condition of a hearing, because we see not only technical issues, but even inadequate postures of attorneys and witnesses with t-shirts, of summer t-shirts. And, I've seen, so in the conduction, it's even funny to say, but in the rules of conduction of these virtual hearings, sometimes you have to be very clear in the posture of the witnesses, and that they cannot participate of the hearing through their mobile, because sometimes they will have to access documents in order to answer a few questions. So also, I think that I'm going to talk about CAMS-CBC later on. So when CAMS-CBC, we do have these rules and this checklist, and we have a very well-prepared team that will check and will conduct tests. But for arbitrators who does not have this support, I think it's very important to have a very extensive checklist in order to analyze that. For counsels, as Doug mentioned also, counsels should be prepared for this new normal cross-examination. in order to avoid, for instance, witnesses consulting or tampering or, doing inadequate things that will harm their depositions. So also it's very important if the attorneys to request the arbitrators to establish clear rules how the cross-examination will be conducted. And for instance, that the witnesses will be obliged to show the whole place they're sitting in order to demonstrate that they're not consulting, that there's no one there in the room, and other, details that, so counsel should be not only well prepared to cross-examine in this new norma, but also to request the support of arbitrators to make sure that the experts or the witnesses will conduct in a right way to help arbitral tribunals, decision.
I can say that for me it's impossible right now to have an ad hoc arbitration, because I really depend on the secretary of the chambers. Like to go to a private room, to go to the arbitrators to the private, it's impossible to me to do that alone. So we really need more than ever of the support of the chamber. I have many hearings in country CBC, and this kind of support is perfect. Janet, I'd like to hear from you.
Oh, indeed. Just a few additional comments to add to those excellent remarks. For the arbitrators, I think Doug is absolutely right that initially investing in the basic technology and the time it takes to learn how to be competent with it has been, I think, an important thing for arbitrators around the world to continue in this new environment. But he's absolutely right that there is we see it as a quantity of stimulus, but it's a different kind of stimulus that we have to interpret. I'm sure the watchers will have seen, the viewers will have seen our images sort of just rotating at random as a different person speaks. Well, that's what's going on throughout the hearing. Different people are appearing. They're shifting around. I did find myself, I think, early on in the day, at one point sort of thinking, oh, yes, that's where claimant counsel is sitting over there. And then I said, oh, yes, and would you like to cross-examine this witness? And I sort of reached up and named the person. And suddenly, as I was doing it, I was realizing I was inviting counsel to cross-examine their own witness, because, of course, everything keeps shifting around in front of you. Technology, I think, will help us in due course with that. It will create a visual environment that looks much more like the traditional hearing room. We will know where to look when we're looking out for the witness, when we're looking out at the screen in front of us to see, counsel for the respondent. We will, know where our arbitrators are on our screen. It won't be a sort of ever-changing kaleidoscope of faces. So that's one of the challenges. Also, the other challenge, as Doug says, you don't have the same, at least currently, the same 360 degrees perception of not only who you're looking at and who's looking at you, but also what is the reaction of that person who's not speaking to something else that's going on in the room, which is not a person who is speaking. You have that as an arbitrator. You have a kind of a spidey sense, a peripheral vision, an intuition about what's going on, in addition to what is actually on the main stage. The technology, I think, will also help us to advance that. But for some of the basic things like, is the witness being coached? Is the witness viewing or hearing some other intervention that the witness should not be? I have to say, I've just never seen how that could be possible. Everyone has a front row seat. You see everyone, you see everything, in some ways far more clearly than you did in the room. So those things, I think, are really not at issue. But along with being able to place people on the screen, as Doug has said, it's a far more intense experience for everyone, because it is everything front and center, 24/7 when you're on that platform. And for an arbitrator, there is absolutely no downtime. Almost everyone else can pause for a minute, look away from the screen, reflect on life and living. But for the arbitrator, it's total concentration all of the time. And so that means, as Doug says, that sort of more frequent breaks and perhaps shorter hearing days can actually achieve sometimes more than you might expect. I might also add that for the presiding arbitrator, there is absolutely no escape at any point. So you really have to be absolutely locked on the action throughout. But, let's set the arbitrators aside for a moment, because it really is, we have to acknowledge it is counsel who do the heavy lifting in the case. They're the ones who have to put the case together. They have to see it through. If they reach out physically or electronically for a document and it is not there, heaven help them, there will be a delay, a loss of momentum. The sort of pace of the examination will have been disrupted. It is really on their shoulders to carry the matter forward. So it's for them that I have the greatest sympathy. This has been the largest learning curve for them. One of the huge challenges during the pandemic that will, I think, ease over time is the ability to collaborate closely with their colleagues. When they themselves are all isolated and they have to prepare the case and queue it up from their remote locations, that's enormously difficult. I have, huge sympathy for them in that. If they are able to be together, we still haven't worked out how to provide sort of audio and visual access to each of them that is as effective as we are today when they are together. We need to work on that as well. But when they do work together, they work together brilliantly. And what we are seeing, or at least what I am seeing, is all the more opportunity for the second chairs and the others to have one witness to themselves, to be able to do that examination, to be invited to step in. In the past, it was lovely to have a dinner after the day's hearing with the other arbitrators in some exotic location and say, thank goodness, I'm away from the office and everything else and I can just relax here. But for the counsel teams, it was a very different prospect. If you're a younger arbitrator or younger sort of counsel team member and senior associate perhaps, you may have worked your heart out on a case, but then someone will say, well, we have to go, to the other continent, just to Singapore, or we have to go, to Delhi for that hearing. We can't afford to bring you there for a week. We can't afford to have you out of the office for a week. Today, it's a very different prospect. They can be brought, they can listen in to the matter while they are doing other things. When their turn comes, when the moment comes for them to do an examination, they can be brought on screen. It's a far more efficient and effective process, I think, to bring in new talent and to spread the load. But it is the council who have so much more organizational challenge to face, so much more prep work. They have to, sort of run through the rehearsal. How do I go from this document to that document to the other? When it's all in the same hearing room, you can have slips and fiddles, but when it's in a virtual environment, it has to be seamless. And we're seeing that is a much greater effort on their part to prepare.
Thanks, Janet. We are living some funny situations too in this adaptations. Recently, I had a hearing, and I was a counsel in the case, and I had to present the case to the tribunal. And I prepared myself. I put a panoramic camera because I like to go around, to walk around the room. So I put a panoramic camera. I put myself in front of this, and I put some marks on the ground to be sure that I was in the frame when I walked from one side to the other. And I was about to start, and the president said, no, Fernando, I don't like this way. I don't feel comfortable. Please, I want you to sit in front of your laptop camera and stay seated and do your presentation. Okay, I need 10 minutes to change the things here, but we have to adapt the microphone and everything. I need a breakdown of 10 minutes to a break of 10 minutes to adapt the equipment to start my presentation. So sometimes we have some situations that surprise us, but you have to adapt quickly. I think we will be many different experiences in this field. Just to stay in the same topic, I have a question here from Marcelo Muriel. He says, good morning, everyone. It's not just a matter of hardware for connection, but rather the software currently available for case management. I hope this could be covered by the speakers. One of you wants to talk something about this?
Perhaps Doug might like to jump in, but of course this is so important for infrastructure disputes because especially when we're talking about the document management, the electronic hearing bundles, it is a huge challenge to organize those electronically. Doug is right that many arbitrators like to have their own copy of the paper bundle so that they can cross-reference. But when you've got one screen dedicated to the live transcript and another stream dedicated to the documents, you, at a minimum, if you're working with an electronic bundle, want a separate screen dedicated to your own copy of the documents, because of course counsel have a particular view about which documents you should see and what parts of them are helpful. And you may have a slightly different view as you want to sort of peruse around and browse a bit. But yes, that is a huge challenge. And we're seeing a variety of things. I think Doug can elaborate. A separate witness bundles that are prepared for the witness and put into box, for example, and displayed. Certainly many of the major providers, Epic and Opus, are very helpful in queuing that up and in helping to manage that. There is a new, I think it's a fairly new term. It's a new role that's been described to me as a document jockey. Who is your document jockey? Is it better to have a document jockey on your team or better to have someone from the hearing provider? And I think some of the best teams have, as you quite imagine, a specific person who practices with them and prepares so that the right document is displayed at the right time for the witness and for the arbitrator. Again, that's also another issue. You can't simply hand a document to a witness. My goodness, how will we manage if we can't do that? And to get that document to appear on a screen where it's clearly visible to the witness, heaven forbid the witness is trying to use a handheld. And I'm sure Eleanora will get to that, because having sort of video pods, if you will, for arbitrators or for witnesses who don't have a proper suite themselves to work from can be enormously helpful in that.
Well, I think this is a very important issue. The software for case management. There's a whole range of issues there, and Janet's touched on some of them quite importantly. In the dispute resolution world, domestically and internationally, prior to the pandemic, we had been moving towards electronic hearing bundles and the reduction of the creation of paper hearing bundles. And that was very important. However, those systems were evolving, and the level of cost associated with them was not insignificant. So the service providers, that Janet has mentioned, say Opus and Epic by way of example, don't come cheaply. But the cost of their involvement is directly related to the speed with which they need to work to get a hearing organised. And that is in its own way dependent upon whether the tribunal or the institution can get the parties to think very early on in the dispute about how to use the case management tools that will be helpful because a lot of costs can be alleviated in the rush to a hearing if nothing's been done about the bundle. We haven't, as an arbitral cohort, really organised ourselves terribly well so far as that is concerned. It doesn't tend to be an issue discussed early on in proceedings. It tends to be a question, what case management tools are we going to use, comes up closer to the hearing than it probably should. And I think that's something that we could do a lot better in any event, even for in-person hearings for the future. The other thing that's a bit of a bugbear of mine, and Eleanora will no doubt have a very strong view about this and perhaps solutions that CAM-CCBC is offering, is that I think the institutions have failed to adequately invest in case management, electronic case management tools. And the ICC is a very good example of an organisation that has failed once miserably to establish an electronic case management system and is almost there in its second attempt. But it is far too late, I think, in this technology-rich world for an arbitral institution to say, well, we've got an electronic platform coming by which we're going to be able to provide the parties with assistance with the tools to manage their arbitrations. The SCC's already got a platform. There are other arbitral institutions building them, but the problem is that they're under-resourced, even though, you know, the fees that they earn are not wholly insignificant. And I think that there is room for investment. There's room for investment and innovation. You delighted me by saying, Fernando and Eleanora, that CAM-CCBC has been offering the service of running electronic hearings. That is relatively exceptional amongst institutions, because most have provided a connection to the people who will do it for you. The institutions themselves have not actually gone into that space. Maybe they should, maybe they shouldn't, but it's very encouraging to hear that CAM-CCBC has gone into that space. So I think the question is a very important one for us. What tools are there? How and when should they be deployed? What is the economic value of their use? How can we ensure that we more economically deploy them to the benefit of parties ultimately?
Yeah, I think that Eleonora could comment this. We can connect with the next question. Just how are institutions, and particularly CAN-CCBC, adjusting to the new normal and planning for case administration?
Yes, I'm really glad to say that here in CAM-CCBC, it's a whole different world, as Fernando said. I think we even spoil parties and arbitrators and attorneys here in Brazil, because we take care of everything. Since the pandemic has come, we have issued resolutions in which we have transformed all the proceedings in virtual proceedings, since filing until the delivery of the award, the hearings, everything. And we provide the parties the whole tools, and not only the tools, but also the well-prepared team and case manager in order to assist and to participate in all these stages. So we have increased in our cybersecurity. We have had our team participated in training courses of cybersecurity. We have created very many different layers of protection of the data. This is the first thing. We have like the adequate tools in order for the parties to access the documents, as Muriel mentioned, the software in order to have the bundle or the folders or anything, all the filings of the parties during the hearings. During the hearings, we have an IT personnel present during the whole hearing. So in any technical issue or problem, and it happens all the time, I can tell you. An arbitrator who cannot connect, who did not invest, as Doug suggested, and is from his country house, and so they connect through mobile. So the IT personnel is there in order to help and to solve these problems all the time. Also, the case manager is also present throughout the whole meeting or hearing, and can assist the parties in order to the management or the document management, or even how to assess the witnesses, because sometimes the whole witnesses come in different times, or they don't know where they should participate. Sometimes they're all of them waiting in the waiting room. So our case manager get in touch with them and solve all these disputes, these problems. And also we have the tests, which I think are very important. The rules on conduction of the hearings, they're very clear. They're circulated to all the parties, all the witnesses, in order for them to be prepared how this hearing will be conducted and how should they act and which should be their posture during these virtual hearings. Also, as I told you before, we have prepared ourselves for physical hearings, despite the fact that only 4% of the hearings nowadays are hybrid. We are prepared. We have adapted our physical hearing center, which is very well prepared. I invite you, Doug and Janet, to get to know one day when you can come to Brazil, with all the measures and to ensure. And also we have rules, very strict rules, to conduct these physical hearings, and it's working very well, I can tell. So for the future, what can we expect? Of course, we expect that the virtual hearings and this electronic conduction of the proceedings should go on, but also this physical way of conducting hearings also will go on. We won't have, I say, like, fully booked room with many people, even with full vaccination. So we are prepared for that too. So that's what I'd like to share with you.
Yes, thank you, Eleanora. Janet, you have the ICC experience in Canada. I would like to comment to us.
Oh, well, yes, of course. I mean, as Eleanora is saying, institutions have an enormously important role. Doug and I have a bit of a debate about whether the institutions should be responsible for providing the case platform, if you will, in part because I've always been a little bit concerned that in doing so, they will become potentially such a significant target for cyber attacks and for other sort of skullduggery, that it may actually be preferable to have a sort of a diverse range of commercial providers available to provide that service. But nevertheless, Doug is absolutely right that many of the other institutions are very slow to build up their case platform, their sort of document platform, I should say, systems. Some, like the ICC, are yet to launch. Others, like ICDR, may have a very small limit on what you can upload at one time. So I dare ask, if you want to upload your submissions complete with witness statements and exhibits and experts' reports and so on, can you do it 10 megs at a time? Or is that likely to take about 2 weeks to do? And so it's to some of the others, I think perhaps for security reasons, like the ICDR, have a ways to go. I'm enormously encouraged to hear that CAMC-CBC is going from strength to strength as a great institution in the old normal to a great institution in the new normal in those ways. It's not just document management, though. As Eleanora has said, one of the subtle challenges for all of us is establishing for everyone the sense of gravitas about this. As I've said to some colleagues in other situations, I have visited more kitchens, basement offices, guest bedrooms, of my colleagues in the last year and a half than I ever imagined I would in my life. And this is not necessarily consistent with an important hearing of a matter. And so, especially for witnesses, lawyers can perhaps, and experts can perhaps sort of tune out all of those distractions and focus on what is going on. But for witnesses, very important to give them a sense. Yes, of course, swearing an oath is one thing, but the environment, if it's not a courtroom or a hearing room, how do we instill for them the significance of that moment, the solemnity of the occasion, the importance of, following carefully and telling the truth, for example? That has been a huge challenge for us, and what institutions are able to do to assist that, I think, is very important. As Eleanora has said, the security issue is enormously important, and whatever services arbitral institutions provide, they need to provide security that is of a very different sort from what it was in a physical environment, and it will demand great resources on their part. But ultimately, as Eleanor has said, it's bringing it all together. It's providing the technical rehearsals for all of those who've never been in an arbitration hearing. It's providing the reassurance of the technical interface. It's providing whether it's the document jockeys or the interpreters, providing them with what they need to have good access to the hearing and ensuring that their interpretations are transmitted appropriately, and so on. I was in another webinar recently where it was being simultaneously translated into 2 other languages. And it was only when I realized that there were 3 languages going at the time, at that particular moment, that I realized that was actually a bit new for us. It's something that we've dealt with in the past with different booths in a physical environment, but it's a new challenge for all of us in the virtual environment. Getting the sound right so that you can actually hear a witness and their inflection through the regular channel, but also hear the words being spoken by the interpreter effectively. These are all things that institutions can assist with if they cannot readily be brought together by the arbitrators and the council.
Thanks, Janet. Doug, would you like to complete something on this issue?
No, I think not really. I think we've covered that topic well. It should go into the category of work to do, I think. Eleanora has done a lot of work, but the learning around the world of what CAM-CCBC has done is certainly not as complete as it could be. And sharing the developments so that everyone, albeit in a competitive environment, perhaps between institutions, can learn from what others are doing is important for all of us. And I think that sharing process could be done better.
Thanks, Doug. And Janet, what sort of proactive case management is now possible and will be expected in the future? I think in the future is the more important that we have to concern.
As I hinted at earlier, it is far easier now than it once was to gather the people together to have a discussion about an issue arising in the process of developing the case before the main evidentiary hearing than it ever was. And the thing that is better about it is that you can see one another. You can see all of the people in the room and they can see you. When we spoke about once upon a time about the special qualities of an in-person first case management conference, how the question was whether we could afford and justify the expense of bringing everyone together for that occasion. But nevertheless, how helpful it could be in reassuring the parties. And as I say, I emphasize parties, I mean not just the council, but the commercial parties, that you are actually a person who is on the job, ready to be helpful, capable of directing an arbitration or capable of contributing to the work of the arbitration. That was all a very special thing that was reserved for only the most valuable and most difficult cases. Now that's readily feasible for everyone. And as I mentioned, if I can just sort of elaborate on that point, just as junior counsel can be off screen and viewing what's going on, so too it can be enormously convenient for the parties themselves, the commercial parties who say, who are these people? What is going on? In my case, have we, chosen the right arbitrators? Is this going to work well? They can listen without being on screen, possibly even with next to them the guidance of a council team member to explain to them what's going on. All of that is made possible for the first case management conference through this new platform. But going forward from that, I think it's not new with the pandemic. It's been sort of the last 10 years or so. But in recent years, Doug and I have been emphasizing the benefits of regular engagement with the parties through the process, that it's no longer satisfactory in most arbitrations for the tribunal to issue procedural order number 1 and say, I'll see you at the main evidentiary hearing, everyone. You get on with it yourselves and, only come back to me if you're in real trouble. Rather, there can be huge benefits along the way to setting sort of at least tentative milestone calls to discuss issues as they come up, perhaps after the first exchange of submissions to streamline the issues and discuss the expert evidence that will be needed, to gather together if there's going to be disclosure and exchange of documents, to gather together once the parties have had sort of a go at that and identified their differences, to resolve those differences in a discussion rather than through a battle of the reference schedules. All of that is possible, and now I think in a far more effective way than it was through a teleconference. If only because in the teleconference, you have only the voice to work with. What if there's a silence? Is that a person fuming at what has just been said? Is that a loss of connectivity? Is that a person just pausing to think for a moment? None of those things can readily be interpreted if you're not on screen. And so you can, in fact, be, I think, far more effective in your communications in resolving these issues on a regular basis through the life cycle of the arbitration in a way that I think can save the parties potentially enormous expense, going down blind alleys, calling additional experts that are not going to be needed, and so on.
Great. Thank you, Janet. Eleanora, any comments?
I totally agree with Janet. I think we have an opportunity now with the virtual communication and hearings in order to follow up and to improve the case management. And as Janet said, not just in the beginning of the proceedings or during the expertise production or the technical evidence, especially in construction cases. I think it's very important for the arbitrators to be in contact with the parties and to decide together with the parties how the documents should be produced or presented, and the expertise should be conducted. So I think this is very helpful, and it really increases efficiency of the proceedings, and the technology has come to help us, especially in complex cases such as construction cases.
Yeah. Would you like to add any comment?
Well, I completely agree that this provides an opportunity for an engagement process that previously was not taken advantage of, at much less expense than everyone flying to a place to do a case management conference, either at the beginning or during the process. And we all know that there are some fraught issues, the outcome of which can never be confidently predicted in procedural order number 1. Disclosure, of course, if there is to be any, has become a huge problem in international arbitration in terms of cost. The preparation of written witness statements, the reliance on documents as opposed to them being referred to in witness statements, the use of experts, which I think we might talk about separately. All of those things demand, in my view, intervention by the tribunal on a regular basis with the parties to understand what the case is that's being developed and how the parties could be encouraged to more efficiently and economically get to an outcome. So the use of the video conference adds a dimension to engagement previously not available. However, we should not ignore, because it is very important, I think, that the process of development of procedural management of an arbitration is, or should be, largely consensual. So in many ways, the role of the arbitrator is to mediate the process of disputed procedure, rather than provide the level of direction which a judge would. So I find myself in the Singapore court empowered with the powers of the state, and there's a lot less mediation that goes on there than it does in an arbitration. It's very important, though, in the arbitration to bring the parties with you, so far as a tribunal is concerned, than it is in court. And if the parties have buy-in and are persuaded that the process that's being used is effective, you will find it works a hell of a lot better than otherwise. What we lack, and it should not be ignored, is the capacity in person to read, let me say, read the tea leaves, to watch the reactions, particularly of the party representatives, to debate about procedure. We've already mentioned that the video process doesn't allow that terribly well. Just let me give you an example. A few years ago, I was chairing a tribunal involving a massive dispute involving a 4-unit atomic power facility. The parties had come for a CMC, shall I say, in bulk. There were probably 35 people on each side of the tables. And it was a long table that led off into the distance that they occupied on each side of the tribunal's head table. I had some ideas about how we might make this process work a little more effectively than doing what Janet suggested of PO1 and see you later at the hearing. There were counsel involved in the case from a common law jurisdiction whose reputation for procedural innovation, let us say, was not outstanding. They had their own way of doing things, and that's what they wanted to do. So my suggestions, for instance, of an issues case management conference after the first round of parties exchanges, where the tribunal analysed what it thought the case was about and talked to the parties about what they really needed to do for reply purposes, as opposed to mow down every forest in sight, rather concentrate on the key issues, was not being received with a great deal of enthusiasm by counsel. To put it mildly, one was being told in a very elegant and polite way that it was interesting, from which one could understand that it was generally regarded by counsel as unacceptable, to put it mildly. However, I was noticing down the line, towards the bottom of the list of the 35 people that were there on each side, a level of interaction between the clients across the table and amongst themselves, which counsel, of course, couldn't see because they were looking at the tribunal and they were at the top of the table. There were smiles, there were nods, there were discussion. So I thought, it's time for a cup of tea. So I said, well, you've heard what the tribunal has said. Perhaps we might now take a break for 20 minutes or so and have a cup of tea. So we had a cup of tea. Counsel came back, tails between their legs, and said, we've actually had some discussions during the break and we'd like to adopt what the tribunal is suggesting. Now, the chance of doing that in a video would have been pretty remote. And the other thing is that when you have cups of tea physically in a hearing, there's a necessary interaction on a personal level between tribunal members and counsel and others that occur, which you never get in a video. And my concern, as good as the suggestion is that we should use this new technology to provide the interaction that it's capable of, we shouldn't forget that there is a level of interaction from a mediation perspective in terms of procedure which we can't get from the video. So saying, okay, we're going to have video conferences for all the CMCs and we'll never meet in person is something that I think we need to be a little bit careful about.
I agree with you that we really miss something, some opportunities of mediation of the proceeding when we have the virtual meetings. And Doug, specifically about technical and expert evidence, what changes? What sort of proactive case manage is now possible?
Well, this happens to be one of my favourite topics, if you will pardon me saying so. From a common law perspective, we've had party-appointed experts in domestic proceedings in most common law jurisdictions for a long time. Whereas in the civil law context, domestically, tribunals have relied, courts have relied on court-appointed experts. However, the enthusiasm with which civil lawyers from civil jurisdictions have embraced party-appointed experts has been extraordinary. And now my experience in international arbitration is that it's a pretty rare occasion when you have a tribunal-appointed expert compared to where it might have been the case from the civil law tradition in the past. Sadly, the lawyers trained in the civil system who've embraced with enthusiasm party-appointed experts don't have the long history of the abject failure in the common law system of party-appointed experts actually helping the courts. And there has been one attempt after another to try and reduce the hired gun effect of party-appointed experts in common law domestic proceedings. And that tradition of how do we solve this problem has not really been something that civil lawyers in international arbitration are aware of, because they haven't been part of that long history of abject failure of experts to actually help tribunals. So it is an area where I think there is a huge need for tribunal intervention to try and ensure that experts actually help the tribunal rather than just act as someone else who's part of the counsel team. And I have a series of theories about how to make that work, which have been deployed over the last few years with mixed success, but some extraordinary success from time to time, where parties have saved enormous amounts of money by the tribunal working with the experts from a very early stage of the proceedings to ensure that experts of a like discipline answer the same questions, talk to each other early in the preparation of their reports, have the same databases available to them when they're preparing their reports, and then talk to the tribunal about how they're going in developing their thinking, their methodology, their processes, and the like. With the CMCs that I've been able to deploy in this COVID time, I've managed to have a lot of interaction, counsel present, with experts of like discipline, and to produce outcomes which at the evidentiary hearing mean that the tribunal is really concentrating on what the key differences of principle and assumption are between the experts, rather than having the choice, which is sadly often the case, of do I accept this expert or that expert, as opposed to getting the benefit of the expertise jointly of the two experts within the discipline. So I think in this area, there's a huge value to be obtained. I would imagine that in Brazil, with your civil law tradition, this process of engagement with party-appointed experts would be a relatively normal development of proactive case management by arbitrators. But I'd be very interested in understanding how you've approached that issue in Brazil.
Mm-hmm. Yeah, I don't know. I would like to hear about it from Eleanora, because in my experience, I noticed that when we start to practice arbitration in Brazil in the 90s, we are very enthusiastic with the idea to have part-appointed experts, and but now what I see is that the arbitral tribunals are choosing your own experts, because the image of the part-appointed experts it's not that good, because we are feeling that this part-appointed experts, they are really engaged in the cause of the client. So particularly, I am more enthusiastic right now with the experts of the tribunal. I don't know how are seeing as arbitrator.
Fernando, maybe if you allow me, maybe we can listen to Janet before, and then I can answer the question and jump to the next question already, because I'm going to talk about how expertise is being dealt here in Brazil. So I don't know.
Yeah.
Okay, that's you, Janet.
Just happy to add a few words. I mean, as Doug has said, it's a complete conundrum. In the common law, you have party-appointed experts. And even with the best of intentions, they may well be people of considerable integrity and sincerity. And yet, when they first hear about the case, they're hearing about it from one side. And so not only will counsel, without any ill intent necessarily, be conveying to their experts the state of the factual record that they hope will eventuate, but also they will be in discussions with their experts endorsing a particular methodology that is more favorable and encouraging that methodology, and supporting whatever calculations their expert provides. All of that leads in different directions. So common lawyers may have the sort of grass is greener on the other side view. Well, the way to solve that is to choose one expert. Maybe the civil lawyers had it all right all the time already. Perhaps it's just the independence that you will achieve with a tribunal expert that will solve the problem. But indeed, it does not, because the tribunal does not know the case as well as the parties, as well as the counsel, typically until you ideally come to the hearing, and then the tribunal knows enough about the case. But at that early stage, in directing and guiding the experts, the tribunal is not in as good a position as the counsel are to develop their expert testimony. So how do you bring those two together? And that, I think, is what Doug has been pioneering for all of these years. Again, each of us try to encourage the adoption of approaches that are consistent with this, but you can only go so far. To a certain extent, it can be a legal tradition bias, civil law or common law, where common lawyers, have said to me as co-arbitrators, oh, just let the parties, make their cases the way they want to make their cases, and we'll work it out in the end. It's not necessarily just a question of civil law or common law bias. It is a question of a preparedness to innovate, a preparedness to take a step forward. But these joint commissions of experts can be enormously helpful in bringing the issues together, in allowing, as Doug says, for example, for the tribunal to have the benefit of the methodology that may be more sound on one side, but applied to facts that are being assumed on the other side, if those are what the tribunal decides to be the case. Or having the benefit of the cross-checking of the calculations of one expert when the other expert, who's got the methodology right, has just gone astray in some fashion in some part of the calculations. You don't get the benefit of both unless you find ways to ensure that they join issue. And I think from an arbitrator's perspective, I only ask counsel to be mindful of the fact that, particularly if you're presiding arbitrator, but any member of the tribunal ought to have this concern. We need to know that when we reach the quote-unquote finish line, the end of the hearing, that we really understood that expert evidence, that we really understood where the differences were, where the decision points were, and how that played out in the evidence, so that we've reached a result that we know that the parties will say, okay, we see how they decided and how they chose here and there. And yes, we can understand how that would be the right result. The thing that concerns me is that at the end of the day, we'll be forced to choose between one or the other in some inappropriate way, so that a party will say either, well, I prevailed, but the calculations are so wrong. The calculations are so inadequate that I didn't prevail as I should have. Or yes, the tribunal got it right in this way, but the result is just absurd. It could never match the reality, could never be one that we could accept as a sensible result. So those are my sort of small additions to note before we turn it over to Eleanor.
Thanks, Janet. Eleanora, you're right, because your comments are connected with the next question, is what is happening in Brazil. So please.
Okay, so I totally agree that both methods have advantages and disadvantages, and it is up to the arbitrators to try to take the best of each method, or to pick a method and try to, to overcome the difficulties in the appointed method. Here in Brazil, I have to tell you that we have been following the civil law tradition. We have been appointing tribunals expert because we have faced situations in which parties have produced their evidence through their experts, and we have found the evidence antagonic and impossible for the arbitrator to decide to which conclusion they should follow or they should take into consideration. Of course, that, as Janet mentioned, this method of parties having their own expert has the advantage of leaving to the parties to show the arbitrators which are the critical issues, which are the issues that they really want the arbitral tribunal to decide on. However, as I mentioned, it has been very difficult for us, so we have appointing expert of the tribunal. So what is the disadvantage of that? Of course, the costs, and because both parties will also have their own expert to follow up on the work of the tribunal's expert. So what we have been doing here in Brazil to try to make this procedure more effective, we are gathering the parties, their experts, the expert of the tribunal, and asking them to agree on a terms of reference of the expertise or the evidence to be produced. So they agree on the methodology, how many, or at least if not how many meetings they should have, or how often they should visit, for instance, the plant or the construction, and how the exchange of information among them is going to happen, how often they're going to talk to the arbitral proceedings, to the arbitral tribunal, I mean, because sometimes what we see is that when you don't have clear rules on how this expert evidence will be produced, the arbitral tribunal expert is lost, and they're all the time consulting with the tribunal, and the tribunal will have to consult with the parties to see if the parties want to present their arguments and defense on such issue, and it will take a long way in order to decide the small issue or technical issues, or even methodology of how this expert evidence should be produced. So it seems to me that it's been really useful, this way of dealing, and it's been a way of overcoming the disadvantage of the methodology of arbitral tribunal expert. If not possible to agree on a terms of reference, what at least we have been deciding, I mean, we as arbitral tribunal, is to request the parties to have common critical issues or common questions. This is more difficult. All the time they don't agree with the questions, but at least to have common chart of critical issues in order to the expert tribunal be very clear on what he or she should work on and to conduct the expertise. So I think this has been really helpful, Fernando.
Thank you, Eleonora. I have so many questions here, and I would spend all the day here talking to you, but we are approaching our deadline. So I'd like to invite you all to make our closing statements here. Let's follow the first Janet, then Doug, and then Eleonora.
Just very briefly, to say that as I speak with Eleanora and we hear what's going on with CAMC-CBC, I certainly cannot help but feel that the future is bright, that indeed we are finding our way not just through this pandemic, but into this new normal of virtual hearings, not so that they will entirely replace in-person meetings and hearings, but so that they will give us many more useful tools in the toolkit to be able to provide for more efficient and more effective dispute resolution that saves parties time and cost in resolving their disputes. Nowhere is this more important than with infrastructure disputes. The level of complexity, the level of documents involved, just the sheer quantity of what's going on in an infrastructure dispute, I think demands us to find and advance these new ways of proceeding. And they are most effective, I think, when they are supplemented by the options that we now have in the virtual world.
Thanks, Janet. Doug?
Well, it's been very interesting. I've learned a lot from this discussion, and thank you, Eleonora, for sharing your experiences from Brazil, where I think there is a leading edge developments in a whole range of areas, which I would be encouraging you to share with the international arbitral community to an extent which perhaps has not been done so far. Because that's what international arbitration is about. It's about taking the very best from all of the traditions that are represented in international arbitration and all of us working on continuous development of the mousetrap, how to make it better. I think that what we have found in the pandemic is a whole range of technological opportunities which we as lawyers had ignored, but which had been out there in the community, which provide us with a chance of breaking down the various elements of proactive case management which people should be encouraged as arbitrators and as counsel to encourage, and saying, what can we do with this new technology? What can we do with video conferencing? What can we do with appropriate ways of using database organization to make things more efficient, with an eye always on efficiency and cost saving within the context of a fair outcome for both parties. So the future, despite our depression of when will this thing end, is nevertheless bright, I think. And discussions like this are inspiring. So thank you.
Thank you, Doug. Thank you, Eleanora.
Thank you. First of all, I'd like to thank you, Fernando. Thank Janet. Thank Doug for being here today. It was very good for me. It was an honor to share the experience and to learn a lot from you and from your huge experience. And also, I'd like to thank CAMCCBC team. Everybody is here watching us, and all this good job has been done. Thanks to them. They have been working very, very hard during the pandemic. So my special thanks to everybody from CAMCCBC. And we think that it's our duty to keep on getting better, to be developing in order to make this new normal an adequate place for arbitration to develop even better. And Doug, it's going to be a pleasure for us to share experiences, and just count on us, and we will keep on working. And that's it. Thank you so much.
Thank you, Eleonora. Well, I think that we are not going back to the old way to work with arbitration and to work with everything. It's really a new normal that we're living. We are losing some things from the old way to do that, but the human being is so adaptable, and I think we are learning lessons, and we are going to make our job in the best way, in the better way in the future. So I'd like to thank you, Doug, Janet, and Eleonora. It's really, really an honor to host you here, and I hope you enjoyed this moment. I hope that the audience enjoyed this hour and a half that we share here. And thank you, Lauro, for inviting us to be here. It's really, I'm really happy to be this time here. So thank you all, the audience, and hope to see you personally or virtually very, very soon. Thank you very much.
Thank you.
Thank you, Fernando.
Okay, bye-bye.
Thank you. Bye-bye.